Welcome to the History, Law, and Justice Podcast. I'm your host, Michael Buckner, a lawyer and amateur historian. I will explore with you legal issues affecting governance, society, and culture of the United States and other civilizations, both past and present, using history as my guide. Before we begin the episode, be sure to subscribe to our YouTube channel. Also, you're invited to share your thoughts on today's topic or anything dealing with history and the law in the comment sections below or on our social media platforms. On May 25th, 2020, George Floyd, an unarmed black man, died at the hands of a police officer who had held him down at the neck by his knee for more than 8 minutes. Since that day, numerous demonstrations have occurred throughout the United States to protest the death of Mr. Floyd. Unfortunately, some peaceful demonstrations have been infiltrated by violent elements, which have caused numerous deaths, as well as serious damage to people and property. The right to assemble is protected by the First Amendment to the United States Constitution. Today's episode will review when the First Amendment protections for an assembly end, when it crosses the threshold from peaceful demonstrations to violence. On September 25th, 1789, the United States House of Representatives and the Senate agreed on 12 proposed amendments to the Constitution and submitted the provisions to the states for ratification. On December 15th, 1791, Amendments 3 through 12 were ratified by the required number of states when the Commonwealth of Virginia approved them, and the ratified provisions became known as the Bill of Rights. The First Amendment in these Bill of Rights states, "Congress shall make no law respecting an establishment of religion, or prohibiting the free exercise thereof, or abridging the freedom of speech, or of the press, or the right of the people peacefully to assemble, and to petition the government for a redress of grievances." The concept behind the First Amendment was not novel to the citizens of the new United States. In fact, that concept had been addressed by numerous deliberative bodies before the creation of the new nation. For example, on October 14th, 1774, the First Continental Congress had declared that the inhabitants of the English colonies in North America had a right to peacefully assemble. Further, in 1776, the Commonwealth of Pennsylvania became the first colony to recognize the right to peacefully assemble. Other colonies and later states like North Carolina in 1776, New Hampshire in 1784, and Massachusetts in 1790 followed Pennsylvania's lead on the citizens' right to peaceful assembly. Thus, as the United States came into fruition, the right to assemble was not a new concept. Over the course of American history, the United States Supreme Court has determined the First Amendment protects the right for a citizen to conduct a peaceful public assembly. This right to assemble, however, is not absolute. Although the federal state government cannot prohibit a public assembly, the government can impose restrictions on the time, place, and manner of a peaceful assembly as long as the restrictions are justified without reference to the content of regulated speech, are narrowly tailored to serve a significant governmental interest, and leave open ample alternate channels for the communication of the information. When does an assembly go from a peaceful or even disorderly protest that is protected under the First Amendment to the Constitution and a non-peaceful demonstration that falls outside the protections of the First Amendment? For that answer, we look to the Supreme Court's 1969 decision in Brandenburg versus Ohio. In that case, Charles Brandenburg was a leader of the Ku Klux Klan, and he had addressed a small gathering of Klan members in Ohio. During the speech, which was recorded by invited media members, Brandenburg bemoaned the fate of the white Caucasian race at the hands of the government.
He made anti-black and anti-Semitic statements. He also indicated the possibility of revenge if the federal government continued to suppress the white Caucasian race. Brandenburg announced the Klan would be marching on Washington, D.C. on the 4th of July. Brandenburg was later tried and convicted of violating an Ohio statute which made it a crime to advocate the duty and necessity of crime, sabotage, or unlawful methods of terrorism as a means of accomplishing industrial or political reform. He was fined and sentenced to serve 1 to 10 years in prison. Brandenburg appealed his case to the Supreme Court. The court, looking at the protections of the First Amendment, developed what is called the imminent violence standard. Under that standard, it allows a federal or state government to forbid or prohibit the advocacy of the use of force only when such advocacy is directed to inciting or producing imminent lawlessness action and is likely to incite or produce such action. The Supreme Court's decision in Brandenburg still leaves a lot of questions to be answered regarding the right to assemble or associate with groups that advocate or engage in specific violence. What we do know is that the First Amendment protects peaceful assemblies of citizens. Further, we know that the Supreme Court will require showing that a clear and present danger or an imminent incitement of lawlessness must exist before the government may restrict the right to freely assemble.
You're just listening to the History, Law, and Justice podcast with your host, Michael Buckner. Thank you for your attention. If you have any questions or feedback on this episode, Michael's contact information is included in the description box. Citations to sources used to prepare this episode are also listed in the description box. Finally, don't forget to click on the link to subscribe to receive the next episode of this podcast. Remember to let history serve as your roadmap for future success.